this hour from Los Angeles, California, trial attorney Rachel Fiset. Rachel, great to have you on the program this evening.
Thanks for having me, Michael.
All right, so I want to begin there, the idea that the state's case is coming to a close. I mean, one of the things that I think has been a constant theme is that all of these law enforcement witnesses, one of the issues when you're trying a case against an officer is a lot of the officers that you're going to have to call to the stand may not be on your team. And I think we've seen that again today, especially with the state's first witness. You know, I think he ended up being a very strong witness for the defense. Again, your thoughts on just navigating that part of the trial for the state?
This is a really hard case for the prosecution. You have the video showing that she thinks it's a mistake. You have other officers kind of envisioning themselves in the same position. And even the state's witnesses tend to be pro-defense. So in general, calling a prosecution against an officer in almost the worst of circumstances is still a difficult prosecution. And here it seems even harder.
Yeah, you know, interestingly, I thought now this was the part where when you start getting into the use of force expert, the training that she's going into, this should be the heart of the state's case. And it's still not going extremely well. I thought today was a better day as far as the second witness went and talking about the training, because I think a major part of the state's case is the idea that she had all this training. So to make this mistake rises to the level of more than a mistake.
That is what they're trying to show, and there are components of this that seem to support that. However, they're not quite getting there yet. It sounds like the jury's not as interested in the training as they should be. As the reports are showing, they might be getting a little sleepy. The taser is interesting. You have a prop, you have showing of what should be going on. But I think the prosecution has a very difficult case here.
Let me ask you a question. You know, as we heard in the arguments, Earl Gray was talking about, look, you know, I can't be responsible for if they're not prepping their witnesses properly, talking about Michael Johnson's answer to a question. And I'm wondering if you think this is an issue of preparation, because I submit that if you're trying to prepare witnesses who aren't necessarily on your side and want to help the defendant, which I think is a fair characterization of a lot of these witnesses, oftentimes, no matter how much you prep, you can't really anticipate what they're going to say because they may hold things back. Your thoughts?
It is so often that in prep, a witness will say one thing, and then when they get on the stand, both a combination of nerves, seeing the defendant, walking in that person's shoes, it changes the landscape of what they might say. And in a case, I think, particular where you have officers all, again, on the same team, that it really does switch. And preparation is great, and it always makes things better, but sometimes you cannot control your witness no matter how hard you try.
All right, the other big thing coming out of today in the last couple of seconds we have left, the motions that were brought by the state trying to preclude testimony from lay witnesses or police officers that have them sounding like experts, talking about that, also about the bias, trying to bring in the fact that she was part of the union, that may go to bias. Your thoughts on the ruling by the judge and whether they went the right way?
I think the ruling went the right way. It came out how it should. These motions, you know, I think in some ways they had to make them because things weren't going their way, but the ruling came out she made the correct decision.
All right, Rachel Fiset, stand by. We're going to take a break right now. But before we go to break,